Hi, my name is Helen Ward. I'm the president of Kids First Parent Association of Canada, and I'd like to share some lessons from history and law about parent-child rights in Canada. We've heard some recent outrageous comments that there are no parental-child rights in Canada, and I'm just here to correct that. So let's get started. Go. So this presentation is from Kids First. So it's kidsfirstcanada.org. That's where you'll find us. We began in 1987 and we're a registered society and a registered charity in Canada. So the title of this talk is Parent-Child Rights Are for Real, Lessons from History and Law. So recently, on February the 8th, 2024, a BC politician claimed there's no parental rights in Canada. His name is Randall Garrison. He's the NDP MP for Esquimalt, Saanich, and Sooke area. You can hear what he said at that Twitter link if you'd like to look at that. There's no such thing as parental rights in Canada. There are parental responsibilities. That's what he said. The issue of parent-child relationships and parent-child rights has been getting a great deal of attention just recently. So we had his ridiculous comments on February the 8th, and a couple days later we had the BC United leader, Kevin Falcon, saying parents are the most important custodians of their children. And just a few days before that, the BC NDP Premier, David Eby, said, there's no more sacred a relationship than parent and child. So we have a lot of warm, mushy statements about parent-child relationship, but what about rights? Because rights are where the rubber hits the road. So we can have all this warmth about the relationship, but not so much about the rights. And Mr. Garrison is part of the federal NDP, and this is from their website, the federal NDP's website. There's a lovely picture here of Jagmeet Singh, the leader of the NDP, with a family, children and parent at a picnic. Lovely pro-family, pro-child parent relationship photos. Optics, here again, the NDP leader with family, parents, and child. And Mr. Singh has a particular tribute to his own parents on his website, and especially makes a tribute to his own mom, who was the biggest influence in his life. And there's a lovely photo of Mr. Singh and his wife, his pregnant wife, an announcement of their first child. So a lot of pro-family, pro-parent-child relationship optics, but what about the rights? So we're suggesting that you respectfully demand that Mr. Singh, the leader of the NDP, ask for MP Garrison's removal, resignation, or at least an apology. So you can contact Mr. Singh at jagmeet.singh@parle.gc.ca. There's phone numbers there too. You can contact Mr. Garrison at randall.garrison@parle.gc.ca, and there are his contact numbers with a respectful demand to step down or resign or at least apologize to the parents and children of this country. When these kinds of outrageous statements are made, I get a bit triggered. And so here's some images of mother bears and their cubs to inspire us, because this is a very fundamental, very basic reality, parent-child rights. And we will fight. See this mother bear fighting for her cubs? Well, we will fight and we will win. Here's some lessons from history. Canada has a long, tragic history of ignoring and violating parent-child relationship. We know the history of colonization because it repeats. So this is a photo of, or a picture of Reverend Edgerton Ryerson. And in the mid-1800s, devout Christians like Edgerton Ryerson set up the system of compulsory attendance in state-run schools and also set up the residential school system. This was a colonization of the parent-child relationship. And the only reason that the state could do this was because there were no human rights laws. So they could act unilaterally to just ignore the parent-child relationship and parental rights and parent-child rights. So we've learned a lot about residential schools and the tragic outcomes of that system a lot in recent years. It's just some reminders here. What happens when the state ignores the parent-child relationship and parent-child rights. It wasn't just Indigenous children who were put in residential schools, but the BC government put Doukhobor children in schools. So the Doukhobor children, those families, the BC government disapproved of their religious practices and thought the children better be separated from the parents, and so they did so. And the caption here is "A Decade of Hell for Children at the New Denver Sanatorium." Children were taken from their parents. And wouldn't you know, isn't it ironic that just about a week before NDP MP Garrison made those outrageous comments, the BC Premier apologized for violating parent-child relationship of the Doukhobor families. It was the Sons of Freedom subsect of the Doukhobor community that suffered this indignity. And the Premier is aiming to apologize. And there'll be a compensation package of about $10 million to that community, or the remnants of it. Here's a photo of the children behind the chain link fence, their parents visiting. In his statement, Premier Eby said, "After many years of unrest and troubled relationships, the province forcibly removed children from their homes and communities, leaving parents to visit kids through chain link fences. Courts would not let this happen today because of human rights laws. And it should not have happened then. There is no more sacred a relationship than parent and child, and that relationship was broken for a whole community, resulting in harms that have echoed for generations. Today we acknowledge the pain experienced by Sons of Freedom Doukhobor children and families." Now, our Premier, David Eby, is a human rights lawyer of some note, and he's surely aware that the reason that the courts would not let this happen today is because of human rights law. Protecting parental rights and children's rights and everybody's rights and religious rights and association rights and of all sorts. So this is, it doesn't actually mention rights. He just mentions the relationship, but the relationship is also protected by rights. History also tells us of extreme, other extreme violations of parent-child rights, including in Cambodia under the Khmer Rouge and Pol Pot in the 1970s, where children were taught in schools that parents were bad and the state was good. Children were encouraged to report their parents to the state, resulting in many murders. And the death toll in Cambodia was in the millions for a variety of reasons, but this state needs to be very cautious in its relationship with the parent-child relationship, and we should learn this from history in Canada and elsewhere. There's also lessons from law. So we have laws about what a child is. You're a minor if you're not an adult. So it's provinces that determine the age of majority when you are a legal adult. So the age of majority is 18 in Alberta, Manitoba, Ontario, PEI, Quebec, and Saskatchewan. And it's 19 in BC, New Brunswick, Newfoundland, Northwest Territories, Nova Scotia, Nunavut, and Yukon. So that's people who are younger than that age are children, legally speaking. And as a child minor, you are very restricted in many ways. So there's mandatory school attendance, education program, participation from age 6 to 16, at least in BC. You are subject to family policing under child protection services. You can't just go in and buy a lighter or even matches sometimes. You can't buy knives, you can't buy guns, you can't buy or drink alcohol, you can't buy or use marijuana, you can't drive a car until you've had some training, and you can't starting age 16 at the earliest. And you can't drive a taxi or an Uber or a commercial vehicle or a bus until you're at least 19 in BC. You can't have your own bank account or credit card. You can't get a bank loan. You can't rent a suite or a hotel or a car. You can't have sexual contact with anybody 18 and over. And your entertainment options are limited until you're an adult. And there's other restrictions too. That's because you're a child. What rights do parents and children have? We're going to look at the Charter, the Canadian Charter of Rights and Freedoms, some Supreme Court of Canada decisions and other decisions, international human rights agreements, and provincial and territorial human rights codes. So you're talking about the Charter. A good resource is the Ministry of Justice's Charterpedia. That's the link there. Gives you lots of good information and insight. And the thing about the Charter, basically, compulsory school attendance laws violate all our Charter rights. That's why it would not be legal to bring in such a law nowadays. Sort of grandfathered in this system. So here's Section 2 of the Charter guarantees fundamental freedoms: freedom of conscience, religion, which is a sincerely held belief with a connection to the divine. It guarantees a freedom of thought, belief, opinion, and expression. It guarantees peaceful assembly and freedom of association, which means you can spend your time with those who you want to spend your time with. Obviously, compulsory school laws violate all of these rights. So that's why I say it's not a system that respects rights, because it doesn't. Under Section 7 of the Charter, we all have the right to life, liberty, and security of person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. The principles of fundamental justice include things like a fair trial, proper evidence, no hearsay, and the presumption of innocence. And these principles are routinely violated now when we hear people saying parents will harm their children, they will abuse their children. When they say these things with no evidence, no hearing, no nothing, and that's a violation of these principles. Getting onto the principle of liberty. So the Supreme Court of Canada has determined that this includes a protected sphere of parental decision making in which parents to ensure their children's well-being. For example, a right to make decisions concerning a child's education and health. So when people assume that children are going to abuse their kids without any evidence, they're violating parents' liberty rights without due regard to the principles of fundamental justice. So they need to stop it. Section 8 of the Charter says we have the right to be secure against unreasonable search and seizure. This is where our privacy and personal information and data is protected in law. So the values underlying the privacy interests protected by Section 8 are dignity, integrity, and autonomy. Protection Section 8 provides for privacy is essential not only to human dignity, but also to the functioning of our democratic society. As such, Section 8 protects a sphere of individual autonomy within which people have the right to be let alone and on which the state cannot intrude without permission. Why am I talking about this privacy right? It's because in schools now, it's routine that children's and parents' and families' privacy rights are violated. Children are routinely, from kindergarten to grade 12, asked personal questions about what they ate, who they hang out with, where they live, what their beliefs are, what their religion is, what their personality is, what activities do you do, who lives in your house, what language do you speak, how many times do you shower, what kind of car do you drive, how much energy does your family use, and also questions about people's sexual behavior and their other kinds of behavior. It's none of the school's business. It's a violation of Section 8. Is routine in schools now, especially in courses about personal development and what do they call it? Personal planning courses, career planning courses. This is social emotional learning. Kids are asked to talk about their personalities and their beliefs and all these sorts of things routinely. in violation of this right, and also in violation of norms of decency, boundaries, and consent. Remember, the whole situation in school is a consent-free zone. So there's another way schools violate parent-child rights. Another law we need to look at is the BC Infants Act medical consent section and the 1993 Supreme Court case that sought to quash that law. So the BC Infants Act deals with so-called mature minors, though the term mature minors does not exist in the law in BC. Other provinces might use that term. But under these laws, minors can refuse or consent to healthcare if a healthcare provider feels that has been satisfied, whatever that means, that the infant understands the pros and cons of the healthcare, and also the healthcare provider must make reasonable efforts to determine and conclude that the healthcare is in the infant's best interests. So this law went into place basically 1992 in BC and was taken to court in 1993 in a case in the BC Supreme Court. And the judge ruled regarding this law, because the law was not struck down, but the only reason that the law was kept is interesting. The judge ruled that it is abundantly plain that the law recognizes that there is a right and a duty of parents to determine whether or not to seek medical advice in respect of their child, and having received advice to give or withhold consent to medical treatment. So the judge says there is a right and a duty of parents. And medical treatment is often an issue these days, isn't it? The judge said courts have found comfort in placing the responsibility for deciding what is in the best interest of a child in the hands of medical practitioners, for they know that medical practitioners will be held accountable by their professional body if they fail to properly use this responsibility. So one of the reasons the courts trust doctors is because they know doctors can be sued, healthcare providers. And healthcare providers must make reasonable efforts to determine that the treatment is in the minor's best interest. And this will include consultation with concerned parents, because such consultation will be required to determine that the health care is in the infant's best interests. I'm thinking in particular of circumstances in which the prior medical history is required, where questions of sensitivity to drugs might be involved, where the post-treatment care by responsible adults will be needed, where the child's parents must bear responsibility for the cost of care. If health care is to be in a child's best interest, healthcare providers will need to be sensitive to and respect the culture and particularly the belief systems of the family of which the child continues to be a member. And certainly all healthcare providers must be aware of the importance of family relationships to the emotional, physical, and spiritual well-being of their patient. Healthcare providers was defined very broadly to include not just doctors, dentists, and nurses, but people providing any kind of therapeutic or preventative treatment. This certainly would not include teachers, but it might include school counselors. It wouldn't include vice principals or school trustees or MPs. Those are not healthcare providers. So it's the parents must be consulted by healthcare providers because it must be in the child's best interest. And so the fact that this law was not struck down, that result ought not to be regarded as a license for doctors to disregard the wishes of parents on this matter whenever they find it convenient to do so. Any doctor who behaves in such a way would be failing in his professional responsibilities, and I would expect him to be treated accordingly by his own professional body. So the judge focused on doctors, not thinking back in 1993 that all sorts of people seem to be acting as healthcare providers to children these days, including teachers and vice principals and MPs and all sorts of folks who seem to feel that they have the right to intervene in that relationship without any legal liability. The only reasons medical people are trusted is because they're legally liable and can be sued. So that's what the judge was referring to. So here's some Supreme Court of Canada and BC court decisions. One of the main cases on parent-child rights is the BR case. The Supreme Court of Canada ruled that the right to nurture a child, to care for its development, and to make decisions for it in fundamental matters such as medical care are part of the liberty interests of a parent. Parents are in the best position to take care of their children and make all the decisions necessary to ensure their well-being. This recognition was based on the presumption that parents act in the best interest of their child. Parental interest in bringing up, nurturing, and caring for a child, including medical care and moral upbringing, is an individual interest of fundamental importance to our society. Continuing from the BR case, while parents bear responsibilities towards their children, they must enjoy relative rights to exercise them. Parents should make important decisions affecting their children because parents are more likely to appreciate the best interests of their children and because the state is ill-equipped to make such decisions itself. That's an understatement. I mean, when the state has stepped in to make these decisions, we've seen disastrous results all throughout Canadian history. I mean, there's a residential schools, a 60s scoop, and it goes on and on and on. And yes, we have rights because we have responsibilities. There's not such a thing as responsibilities without rights, Mr. Garrison. So I hope you'll find this informative. And regarding this conflict between parents' rights and children's rights, well, children are unable to assert these charter rights, and so society accordingly presumes that parents will exercise their freedom of choice in a manner that does not offend the rights of their children. State interference in order to balance the rights of parents and children will arise only in exceptional cases. The state can properly intervene in situations where parental conduct falls below the socially accepted threshold. So the state can't intervene without proper evidence of harm, proper due process, and presumption of innocence. And so when the state is routinely intervening without any evidence and without even any investigation, and this is completely out of line. Regarding security of person, in a case where imprisoned moms of babies and young children won the reestablishment of a program so they could have their babies with them in prison, the court found that the children's and the mother's charter right to security of person includes breastfeeding and attachment. The parent-child relationship is an attachment relationship that is part of our security of person. So it's protected under Section 7 of the Charter. Check it out. Schools have been taken to court many times. In the Chamberlain Surrey School Books case, which is very relevant to current discussions, the court found, the Supreme Court of Canada found that the school board must act in a way that promotes and respects tolerance and respect for all the diverse groups that it represents and serves. All, not some, not one, not a few, all. The words secular and non-sectarian in the BC School Act imply that no single conception of morality can be allowed to deny or exclude opposed points of view. So you've got a lot of points of view there to include in your school system. Pretty challenging, but that's what you're obliged to do. That parental duty includes the sole and primary responsibility to oversee all aspects of day-to-day life and long-term well-being, as well as major decisions with regard to education, religion, health, and well-being. This is consonant with the privileged parental role in the upbringing of their children. Again, Supreme Court of Canada has affirmed parents, not the state. Another case that went to the Supreme Court was the Ross versus New Brunswick School District number 15. The court said that public school teachers assume a position of influence and trust over their students and must be seen to be impartial and tolerant. A school board has a duty to maintain a positive school environment for all persons served by it and must be ever vigilant of anything that might interfere with this duty. The right of children in the school board to be educated in a school system that is free from bias, prejudice, and intolerance relevant to this particular context is the vulnerability of young children to the messages conveyed by their teachers. In this case, a teacher was making anti-Semitic, anti-Jewish statements in and out of school. And that's the whole case was about. So the court also said what this evidence discloses is a poisoned educational environment in which Jewish children perceived the potential for misconduct and are likely to feel isolated and suffer a loss of self-esteem on the basis of their Judaism. Lots of kids are feeling like this in the school system now. Maybe it's not their Judaism, maybe it's another religious belief or another thought system that they adhere to that is not being respected. The state, as employer, has a duty to ensure that the fulfillment of public functions is undertaken in a manner that does not undermine public trust and confidence, and ensure that the educational services are discrimination-free. Where a poisoned environment within the school system is traceable to the off-duty conduct of a teacher, that is likely to produce a corresponding loss of confidence in the teacher and the system as a whole, then the off-duty conduct of the teacher is relevant. So I think our public confidence in the school system is at an all-time low in Canada right now. Public trust is completely undermined for many, many families. They're seeking to get out of the system. They don't know what to do being in the system. And again, in the Ross decision, school is a communication center for a whole range of values and aspirations of a society. The school is an arena for the exchange of ideas and must therefore be premised upon principles of tolerance and impartiality so that all persons within the school environment feel equally free to participate. And that's not happening. So our schools are routinely ignoring Supreme Court of Canada rulings and the law and the charter and carrying on in the way they are currently carrying on. And premiers and politicians who are thinking that they'll restrict the parent-child rights to certain ages. That's you're a minor until you're 18 or 19, depending what province or territory you live in. So to say that the children who are 16 or 15 or 17 don't get the protection of parent-child rights that are enshrined in law is incorrect and wrong. The BC Court of Appeal had a case regarding teachers' political expression in classrooms in 2005. Judge Lowry said that if teachers are permitted to use public schools as forums to advance particular political agendas, they will undermine an open and supportive education environment, and ultimately that will detract from the fundamental objective of the school system. Public confidence in the system is also of vital importance, as the proper functioning of the school system is dependent upon public support, and in particular, the support of parents. So, yeah, you can't just do what you want in the school system because it affects public confidence. In another case regarding a teacher in BC, the court ruled if a teacher acts in an improper way on or off the job, there may be a loss of public confidence in the teacher and the public school system, and a loss of respect by students for the teacher involved and other teachers generally, and there may be controversy within the school and within the community which disrupts the proper carrying on of the education system. So that's what's happening now. To hold an individual in contempt or to judge them based not on their actual individual capacities, but on stereotypical characteristics ascribed to them because they are attributed to the group of which the individuals are a member, is to treat that individual in a manner which is not consonant with their inherent dignity. Statements and actions based on such judgments are the hallmark of discrimination. So parents are being described as people who abuse their kids and who cannot be trusted, and the teachers and the other school professionals and whatnot are assuming that they are to be trusted. And this is hallmark characteristic of discrimination. In another BC Court of Appeal decision regarding schools and teachers in 2013, the court said where the issue upon which teachers choose to exercise their right to free speech is a political one, their rights must be balanced against the rights of students to an education that is free from bias. Exposure to only one view of an issue where there are legitimate competing views could represent a failure to uphold the principles of tolerance and impartiality that the education system must promote and foster. Well, that's happening. So there we go. Human rights, parent-child rights. So international human rights agreements are very strong, again, on parents and parent-child rights. If you're looking for very good information on this, the Declaration of the Authority of Parents and Guardians in the Education of Their Children is a document that is linked here. There's two links, and they will get you to quotes from the ones I'm going to cite and other international agreements as well. Okay, so the Universal Declaration of Human Rights, Article 16, said that the family, not the state, is the natural and fundamental group unit of society and is entitled to protection by society and the state. The family, not the school, not the classroom. No. Article 26 says parents have a prior right to choose the kind of education that shall be given to their children. Parents. The rights of the child. The best interest of the child shall be the guiding principle of those responsible for his education and guidance. That responsibility lies in the first place with his parents. Parents, not anybody else. The Convention Against Discrimination in Education. The state parties to this convention agree that it is essential to respect the liberty of parents to ensure the religious and moral education of children in conformity with their own convictions. Convention on the Rights of the Child in the preamble. The state parties to the present convention convinced that the family is the fundamental group of society and the natural environment for the growth and well-being of its members and particularly children, and recognizing that the child, for the full and harmonious development of his or her personality, should grow up in a family environment in an atmosphere of happiness, love, and understanding. Article 5 says the state party shall respect the responsibilities, rights, and duties of parents to provide, in a manner consistent with the evolving capacities of the child, appropriate direction and guidance in the exercise by the child of the rights recognized in the present convention. This is why I use the term parent-child rights, because the children's rights are protected by their parents. As the Supreme Court of Canada recognized, children can't exercise their charter rights. So parents are trusted with that decision. And Article 29, state parties agree to the education of the child, that the education of the child shall be directed to the development of respect for the child's parents, his or her own cultural identity, language, and values. So the education system is supposed to develop respect for the child's parents. Declaration on the elimination of all forms of intolerance and of discrimination based on religion or belief. The parents have the right to organize a life within the family in accordance with their religion or belief, and bearing in mind the moral education in which they believe the child should be brought up in. Every child shall enjoy the right to have access to education in the matter of religion or belief in accordance with the wishes of his parents, and shall not be compelled to receive teaching on religion or belief against the wishes of his parents or legal guardians, the best interest of the child being the guiding principle. The child shall be protected from any form of discrimination on the ground of religion or belief. There we go. Human rights codes in the provinces, in the country, and the territories also prohibit discrimination in education and other service. So you cannot discriminate based on race, national or ethnic origin, color, religion, sex, age, mental or physical disability. So religion is often relevant in these issues. And you also cannot discriminate based on family status. So family status includes the status of being a parent of a minor child or being the minor child of a parent. So discriminating against parents is illegal, just the way you can't discriminate based on race and all the rest of it. So the statements that are made by people like Mr. Garrison and others that assume that parents are abusive, those are discriminatory statements. They're saying this group of people they're abusive. That group of people can include parents. Marital status, you can't discriminate because a parent is a single parent or something like that. You can't discriminate based on sexual orientation. That's difficult to find, but it could well include the orientation to have and raise children and to prioritize those activities. Gender identity can include the identity of being a mama bear or papa bear, someone who prioritizes raising and protecting their children. And your gender expression can include expression in the form of having and raising children and prioritizing the care and protection of your children. And you can't discriminate based on the source of income. So that's the end of my lessons for those who want to know about parental rights in Canada, that they do exist. And again, I suggest that you respectfully demand that the NDP federally have Randall Garrison removed or resign or apologize to the parents and children of this country. Again, there's Jagmeet Singh's contact information and Randall Garrison's contact information. Again, only respectful appeals are recommended. So thank you very much. Again, I'm Helen Ward. I'm the president of Kids First Parent Association of Canada. I hope you've enjoyed this, and thanks for listening.